Hello, good afternoon, everyone. Welcome, Sneha, to this session. Sorry about this slight delay, but I'll quickly introduce you and then we can begin. So, my name is Dr. Mugdha Lele, and on behalf of the TechX.in team at Venture Center, I'm happy to host the fourth wave of our Only One Theme talk series on innovation management. So, as the organizer for this series, I will briefly introduce Sneha, who is today's speaker. So Sneha's topic is patenting computer-related inventions in India. And she is the founder of PatentSKY, which is a company established in 2017 with the mission of um, democratizing IP services across India. With over 14 years of experience in innovation lifecycle management and intellectual property rights, Sneha excels in idea to patent portfolio creation, patent analytics, um, and strategic IP planning. She's a registered patent agent, design and trademark agent with the Government of India. She's the alumnus of National Law School, Bangalore, and holds a degree in pharma, IPR law, and business law. Importantly, Sneha is also registered in IP Facilitator or IP Mitra under the SIPP scheme, and she has mentored over 750 Indian startups on effective IP management, including her current role mentoring at Catalyst at IIT Mandi. Beyond her work at PatentSKY, Sneha is also sought after speaker, a panelist, and a podcast host for Speaker IP. Sneha, with this brief introduction, we welcome you to the session and handing over the session to you.
Thank you so much, Dr. Mutha. It is always a pleasure to be speaking at Venture Center. And today it's especially because this topic is something which is very relevant these days. So it's my pleasure to be here today amongst all of you. And I think, shall we start or are we waiting for someone to join in?
We can start. People will keep on joining. Most of them have.
Sounds good. So do let me know if you're able to see the slides.
Yeah.
Okay. So our topic today is patenting computer-related inventions in India. And the reason why this is so relevant is because why am I talking? The reason is very simple. It is still a sort of a gray area. Earlier, if you had asked me 10 years, 15 years back, that is software patenting allowed in India, I would have said no. So the reason was that because the patent law at that time said that softwares, computer programs per se are something which is not patentable. Today, I work with a lot of startups, and most of them, the first question which comes to me is that, ma'am, we are working on an app. So is this patentable? And then they are solving multiple different problems. Sometimes the problems are something which are technical in nature. Sometimes there are some problems which sort of it is just an automation of an existing process. But then they are still solving that problem with the help of some computer related invention. And so today when people ask me, ma'am, is this something which is patentable? For me, the answer is not a straight no, it is a maybe. And that is what I would like to talk you through in the next 1 hour or so. I would like to keep it as an open session. Please raise your hands, put your questions in the comments box, and I'll be happy to take the questions as we go. Idea is to make out the most out of whatever time we have today. And also, it is good to have an interactive session. So keep those questions coming. We have a small amount of time at the end of the talk as well for taking your questions, and I would be happy to answer those. So computer-related inventions. Let's first sort of understand what is it that is a computer-related invention. What comes under
Sneha?
that? Yeah.
Yeah, sorry, just a moment.
Sure.
Is there a possibility to increase your voice slightly,
Increase
some
the
volume, I mean?
Let me just
Yeah.
check. Sorry, I've got a bad cough.
Oh, okay.
Yeah. So it's the reason why. The system volume is too full.
Okay. Maybe you can speak closer to the mic or something.
Let me try to turn off the video then. And maybe
Okay, try that because otherwise your voice is not cutting or anything.
But I'm able to hear very clearly, so I'm just wondering if it's a problem for everybody.
Yeah,
Let
there
me
was a
just
message in
try,
chat. That is what
try
I
to
was
speak
checking.
a bit
Yeah,
louder. Is this better?
yeah, yeah,
Yeah,
that
yeah,
is better.
this is fine,
Yes.
Sneha.
Yeah,
Please go
actually,
ahead.
I'm talking a little bit softer because of the cold. Fine. So yeah. So the reason why today's topic is relevant is even now it is not something which is sort of crystal clear. Okay, other areas of patenting, when you ask me, I would have a much better answer to the question. But when someone says that we are developing this computer related invention, software based system, algorithm, then I have to ask them many more questions to understand. Because if you look at this image on the left hand side, many of you must have played this game, the Minesweeper. Today, with the AI, ML, deep learning, quantum computing, NLPs, LLMs, this is a game which we are playing in the field of computer-related inventions. So you cannot be very sure what is it that would get a patent protection. There are certain parameters upon which you have to test the invention, then file for the application, and hope that the patent office sees this as something which would be excluded from section 3K, which does not allow patenting of software related inventions. So what are CRIs? CRIs are basically computer related inventions which involve the use of computers, computer networks, or any programmable apparatus. So it would be realized either wholly or partially by means of a computer hardware or a software. So when I say hardware or software, again, this is a very important criteria, because earlier it was said that hardware plus software is something which is a patentable invention when it is a computer related system. But nowadays, even the hardware parameter is something which is again being reconsidered. So while examining these applications for patents, it is essential to now consider how the innovations transcend, okay, traditionally from being just a software to providing a technical solution. So I understand that underlying it, the tech could be anything, but then is it something which is providing a technical solution is something we are looking at these days from a patentability perspective. Dr. Mugdha, am I audible now?
Yes, ma'am.
Yeah, it's better.
Yeah.
Okay. So,
Yes, yes, Sneha, go ahead.
sure. So today, if you look at a variety of different inventions, most of them, from your smart TVs to your smart fridge to the way you're operating your light switches, as well as how you're communicating with each other, everything has some sort of underlying technology. And these are all integrated techs. So you're looking at healthcare, early diagnostic interventions, you're looking at finance, looking at adaptive learning tools, also enhancing overall system intelligence. We are looking at many IoT based applications which are coming up, which are solving real life problems, but with some underlying tech needs. We are also revolutionizing the human computer interaction. So your virtual assistants, your deep learning, your AI, your MS, these all come into picture. We also have quantum algorithms, quantum computing, which is again a leap in faster computing. And it is helping not just in cryptography, climate change, but also in pharmaceutical interventions and development. So again, there are many other technologies which are coming into play. You have your 5G, 6G, you have your cloud computing, IoTs. Okay, so all of these are sort of able to handle extensive data sets and then churn out so the automation actually is helping us to live better, faster. And also deploying these applications rapidly is something which we are seeing. So these days, it's very easy to develop an app. Within 2 days, 3 days time, if you wish, you could develop something new and put it out there. So it also enables in faster data processing. So with all this in mind, computer related inventions and their protection is something which is need of the day, and if not yesterday. So this is something we should be looking at seriously. Amongst all of you, I'm not sure what sort of I'm considering we have a mixed bag of participants. So we have people who may be patent practitioners who have been in this tech domain innovation management space. We would also have people who are startup founders and looking at this for your own work, you would be looking at patenting CRIs. And then there would be some researchers who would be interested. So I would try to keep the talk generalized, but then also it would be getting into the nitty-gritties of what it is that patent office is actually allowing in terms of the CRIs these days. So a very good resource which was shared by the patent office recently, it was published just 3-4 months back, is the CRI guidelines of 2025. And this not only enlists all the legal provisions, they have given a beautiful sort of compilation of the relevant case laws which are developing. They have also given out certain examples, their analysis. So it is a thick 200-page document, but if you go through it, then things have become much more clearer for us these days when it comes to filing and drafting claims for computer-related inventions. And I'm quite lucky and quite happy to say that with these guidelines, earlier it was a hit and miss kind of a situation, wherein we used to have to put in a lot of more effort to understand which claim would be granted by the Indian Patent Office. Now it is much more clearer, simpler for us because sort of we understand that this is what the patent office would allow and this is what would be excluded by section 3K. So various examination procedures is what I would look at. Also, not just CRIs, but also specifically related to AI, ML, blockchain, quantum tech, deep learning, because these are the technologies which are coming up faster. And also we'll look at some excluded subject matter which is related to computer related inventions. So first of all, like all inventions, even software related, computer related inventions, they are judged on the NUN test, which is novelty, which is of course, most of you must be aware that your novelty of your invention is something which will have to be established in a global context. The patent office will carry out a patent literature search and then determine whether your invention actually has novelty with comparison to what is out there in the space. Secondly, it would be utility or industrial application. So anything which is capable. So these days, most of the first parameter is something which is tough to get, but industrial application is easier because these apps and softwares, they are developed particularly for application into utility or industrial needs. So non-obviousness is something which is again sort of a gray area. But if the software is unique, if what you have developed actually has novelty, then it is easier to get away with defining the inventive step. So again, the inventive step under section 21JA, it is defined as a feature which involves any technical advance compared to the existing knowledge or something which has an economic significance. So if your algorithm, your computer program, your computer related invention is actually helping you save money, save time, make the process more efficient, and have some economic implication as well, then it could mean that the invention is not obvious to a person, that it has some inventive step to it. But these are general criteria, these are general legal provisions, so I will not get into details of it. So section 3 is what is most important when we look at computer related inventions. Section 3K particularly, if you look, the Patent Amendment Act of 2002 specifically said that a mathematical business method or a computer program per se or algorithm is something which is not patentable under section 3K of the Act. Now this per se is very important and I'll come to it in a minute. Also, any literary, dramatic, musical, or artistic work, or any aesthetic creation whatsoever, including cinematographic works and television productions, is also not patentable because all these things are covered under copyright. A mere scheme or a rule or a method of performing a mental act, so anything which is abstract in nature, again, would not be patentable. Presentation of information is again copyrightable subject matter. And topography of integrated circuits. There is a different act, which is the IC Design Layout Act, which covers the topography of the ICs. So this is something which is not patentable. But our main focus today is to delve into section 3K and understand that these four limbs, so a mathematical model, a business method, a computer program per se, and algorithm, what is it that will be patentable and what is it that will be excluded. So quickly, I would like to touch base upon this per se. So while examining the patent amendments bill in 2002, the Joint Parliamentary Committee expressed that per se, particularly for computer programs, meant that the intention is not to reject computer programs for the grant of patent if they were inventions. So what it meant was the computer program as such is not patentable, not intended to be granted a patent. But if there is some invention which is on top of it or on ancillary to it, the computer program, then that is something which could be considered as a patentable subject matter. And this was sort of an eye opener because before that it was a blank no for computer programs. So also it is important to note that in India that per se it attached only after the computer programs. So there is still a bar on patenting your business methods, your mathematical equations, and your algorithms as such. Okay. But computer programs, by defining that only the computer program as such would not be patentable, but the other things would be. It's not an absolute bar in this case. So that is also a small legal sort of nitty gritty, which is important in this context. So when the CRI guidelines were published, like I mentioned, significant evolution of jurisprudence has happened over the past few years because the Delhi High Court, they have a separate bench, IPR bench division, which has been set up. And that division is looking at handling IP related applications in the court. So a lot of case studies, a lot of legal understanding is becoming clearer for us. But at the same time, this is something which is inherently dynamic. So if they go to a upper court, then things and the jurisprudence may also change. So as of today, this is what we have, and that I would like to share with you through some case laws. So Farid Alani versus Union of India. This actually was a very sort of a landmark judgment in December 2019. Because the High Court of Delhi then highlighted the importance of adopting a technical effect or a technical contribution test for deciding the patentability of computer programs. So if the invention demonstrates a technical effect or a technical contribution, it is patentable even though it may be based on a computer program. So this is something to keep in mind, and I have been relying a lot on these sort of developed case laws whenever the cases which I handle go to appeal, whenever they go to a hearing. These are the cases which I rely on to sort of work my case with respect to the patentability of the inventions which are in this particular domain. So, and I have had very good response from the patent office because since these are the guidelines which they have put out, they do abide by it. So I can vouch for that. Also, Microsoft versus the Assistant Controller of Patents and Designs. So the Honorable High Court then looked into the technical effect produced by the technical solution of the claimed invention. So what it further then said was that, okay, if there is a technical solution that goes beyond the user interface. So if it is something which is closer to the heart of the computer and the network technology rather than just user interface, then that is something which could be patentable. So the technical aspect of the invention as such as the use of cookies, the two-factor authentication, they are fundamental to functioning of the computer networks and they are not limited to the user interface. So something which involves a complex network level communication protocol, something which is actually having a technical effect with respect to the heart of the computer, the way it works, the way the hardware works, is something which would be called a technical effect. and that is something which could be patentable under Section 3K. Again, this Open TV Inc. versus the Controller General of Patents. So it again clarified that the phrase per se does not qualify to business methods. What it qualifies, what it applies to is only computer programs per se. So the bar in India to grant of business method patents has to be read as an absolute bar. So if it is a business method, if it is just an algorithm which is churning out receipts, okay, or if it is something which is just automation of a normal business which you would have carried out, then that is something which is not patentable subject matter under the Indian patent law. While the decision from the UK and the European Patent Office varies, because there the bar per se is for all. So in India, it is only for computer programs. So that is something which we have to keep in mind while dealing with these kind of applications. Another case law, Microsoft again, it clarified that the mere presence of a mathematical formula, so this is the third limb of the Section 3K, that the mere presence of a mathematical formula in a claim would not necessarily render it a mathematical method claim. So what they mean to say is, even if you have some mathematical formula in your claim, but if it is helping to provide a technical answer to a technical problem, then that is something which the patent office is ready to look at. So mathematical method exclusion is only intended to exclude the mere expression of an intellectual exercise. So for example, the method of solving a quadratic equation would be something that the patent office will consider a mathematical method and will not give a patent grant on it. But using a certain equation to solve a certain problem, let's say for conversion of ADC, so analog to a digital sort of signal. So that conversion, if you're using some underlying mathematical formulas for it, then that is something which the patent office would consider patentable. Again, Raytheon Company versus the Controller General of Patents. So while dealing with exclusion under computer program, the Honorable Delhi High Court in 2023 again reiterated the importance of technical effect or technical contribution test. So it categorically banned the requirement of any novel hardware. What it means is that if your algorithm is something which is patentable, it qualifies the null test, it also is providing a technical effect, a technical solution, then it is not required that a hardware should be new. So a general purpose computer suffices and you should be able to get a claim granted even though the hardware is not new. So this is a very important Raytheon company. This was a very landmark sort of a judgment. Again, coming to Microsoft technology licensing, further the Delhi High Court defined that a claimed invention upon implementation of a general purpose computer, like I said, it could be a general purpose computer, but it must contribute directly to a specific or credible technical effect, which is beyond the mere general processing of the system. So all your compression algorithms, something which is directly contributing to a specific credible technical effect, because it is helping you compress the data and improve the efficacy of your system. So the same hardware is performing much better when you have a compression algorithm on your system. So the inventive contribution of the patent should not only improve the functionality of the system, but also achieve an innovative technical advantage that is clearly defined from and distinct from the ordinary operations expected of such a system. So this is what came out of Microsoft's lawsuit, and again a very remarkable judgment. So ab initio technology further defined what should be a technical effect. So the technical effect, essentially, it said, the Delhi High Court said, is the bridge or the connect between the input and the processor. So if it is something which is a well-designed innovative input in the form of either a process, a system, or a method, which enhances the computational ability of the processor, would undoubtedly result in a technical effect and goes beyond the normal user interface. Again, something which is closer to the heart of the computing. Okay, and they are again looking not just at hardware tweaks, but transcending of the solution so as it is a the answer which is produced has some sort of a technical significance is something which they are looking at these days. So BlackBerry Limited versus Assistant Controller General of Patents. This particularly was an important judgment because it focused upon the implementation and the enablement aspects of your invention. So what it said was that if the invention is something which is purely related to a set, a flow chart, or an instruction or policies which determine the flow without any substantial change to the hardware, then such instructions, even if they have a bearing on the manner in which the flow of data occurs, they would not be entitled to patent protection in India. So like I said, mere automation of your processes is something which may not get a patent. But if it has an underlying technical effect to it, then that is something which we should definitely look at. So now that we have understood the case laws better, I would also look at some example claims. And please go ahead and share your questions if you have them. So I'm not able to see the chat box. So Dr. Mugdha, I would request if you come across the questions, please do let me.
Sure. So I'll be moderating the chat box. If anything
Sure.
appears, I'll alert you.
Sure. Thank you so
Yeah,
much.
there is one question here. I just saw that please clarify more on technical effect. That is a question that I have just seen in the chat box, Neha. So if you want to elaborate a little bit more at this
Sure.
point.
So thank you, Manisha ma'am. Actually, it is a very relevant question. So thank you for that. And my subsequent slides, I have tried to sort of further clarify the technical effect. So just bear with me and let me go through the rest of the slides. And then again, if you have further questions, I'll be happy to answer that as well. So when I say
Sure.
a technical effect, this is what I mean. And I think we have a good example on the slide, which is present itself. So when they say that mathematical methods are not patentable, but if there is a technical effect in terms of method for adaptive noise cancellation in audio devices. So for example, if there is something that is a method for reducing the background noise in an audio signal, wherein it is receiving an audio input, they are applying a mathematical method, which is the FFT, fast Fourier transform, to convert this audio signal to a frequency domain. This is what we mean by a technical effect. Then that is something which the patent office will be open to give you a patent on. So mathematical processing is a part of a larger technical process then. The underlying formula is just being used so that we are able to get some technical effect out of that invention. So the output here is not just a number or an abstract result, but then technically improves the audio signal, which is delivered to a physical device. Similarly, if there is an image processing sort of a software which is maybe looked at, which looks at different MRI images, and then if it is able to build a 3D model out of it, so that the doctors who are performing a surgery are better able to understand what is it that they are looking at, then that is something which is going ahead and producing a technical effect. It is not just something which is giving out a number or an abstract result. And that is the technical effect which the patent office is looking at. So some of the claims which would not be allowed would be the method of generating random numbers and the method of solving quadratic equations, like I said. Similarly, business methods. So a business method, which is just the automation of a business model. So in a banking activity, you're just ensuring that the transactions are happening better, smoother by relying on a software, underlying software. Such a financial software would not be something which is patentable. So a tiered bank service fee calculation or the calculation of the interest which is applicable to the home loan which you have taken, if that is done through a system which is a computer related, that is something which you will not get a patent granted on. Or a method of generating the receipts online, again, just a business method, business model. But if there is a technical improvement in the data security, then it is not just a business method. So if you look at the example which I have given, a method for securing data transmission in online banking. So here the security of the entire system is being improved so that the banking transaction can happen smoothly. Okay, so then this is something which would have a technical effect, a technical improvement, and it is not just a business method. Similarly, there would be softwares which look at subnet deception, which would look at honeypots in your system, and then identify those and build models further to sort of block those out or learn, machine learn, AI learn from them. So that is something which would be again a technical improvement, and it would be something which the patent office would definitely grant a patent on, although it is just a antivirus if you look at it. Okay. So computer programs per se, what is it that the allowed claims would be? Would be a system for adaptive traffic signal control. When I say this, the reason being you would ask what is the technical contribution here? The technical contribution is that there are some sensors which would be deployed at a place. It would be collecting the data, the camera would be placed, it would take out the data, send it to a microprocessor. The microprocessor would then churn out, and then with the help of some technology it would again be outputting the signals so that there is some adaptive traffic signal control. So there would be an underlying algorithm which would manage this entire process. Then that is something which has a technical effect and thus would be patentable. Similarly, data compression softwares, because they help in better cloud storage, they would be computer programs, but still they would be patentable. A method for correcting transmission errors in wireless communication. Again, it is improving the system. So it is improving the efficiency of the system, making it better, faster, and more correct. So this is also something which has a technical effect. A method for efficient memory management in embedded systems, the embedded hardware systems. It is helping the hardware work better, improve its efficacy by the underlying computer program. Again, patentable subject matter. We see a lot of IoT based inventions these days. So they are also, they would be a so secure IoT device communication or IoT based system for monitoring like the weather, the pollution, various IoT based systems for landslide monitoring. These are something which we have seen patents granted on. Similarly, a system for automated drone-based crop monitoring, agri-related inventions, integrated technologies. Many patents are being filed on these as well. So what would constitute as claims falling under Section 3K? So these are something which are not patentable. Just a method for scheduling your employee shifts. So this is something which you would be doing manually, but then when automation came in, of course, it became a computer system. So such a computer program is not something which will be patentable. Similarly, a system for generating business reports, for creating digital art, of course, it would be copyrightable. If it is a digital art which is created by a person or by a AI, it is something which could get copyright protection. But not in India for AI for now, but at least if it is being done manually by a person who's creating digital art, then that would be copyrighted. Again, generating playlists. So a lot of aggregators these days, aggregator apps, wherein you are just pulling out data from different websites, different resources, and then compiling something, a customized list, a customized map, a customized sort of playlist for yourself, movie library for yourself. All these, they are not patentable. System for generating invoices or scheduling your social media posts. Again, no technical effect, no technical problem solved. So this is just common automation. Okay, so it is not even improving the efficacy of your computer networks. So this is again something which is just user face. So the user face is something which is closer to the interface, and then that is what would be not patentable. So an algorithm, the claims allowed which we have seen would be adaptive noise cancellation for hearing aids, real-time video compression, of course, in surveillance cameras, and secure biometric authentication for your mobile devices. something which is an algorithm, but still the patent office would look at it as a patent grant because it has a technical effect which is being produced. And some of the claims which would be rejected under Section 3K would be just a method of tokenizing a text string, or a method of sorting a list of numbers, a method of creating random numbers. Those sort of algorithms would be something which the patent office will not grant you a patent on. So the CRI guidelines actually also look at the examination of inventions related to AI, ML, deep learning, blockchain, and quantum computing. So because these pose unique challenges to the traditional patent frameworks, and they do transcend through a variety of different technologies. So one of the very important requirements is sufficiency of disclosure. Because most of the times what happens is we are not disclosing the software, we are not disclosing the nitty-gritties of how it is happening. So there is no sufficiency of disclosure for enablement. There was one more case study which looked at enablement of your invention. So as long as a person who is equally skilled in the art, okay, he's not able to read your application and come at a point where he is able to develop the exact same invention, then sufficiency of disclosure is something which is not achieved. Okay, so patent law works on quid pro quo approach, that is, in return for giving you a monopoly, you have to completely disclose your invention. So if the sufficiency of disclosure is not there in case of AI, ML, deep learning, blockchain, or quantum computing, then the patent office is in a position to reject your claims. Okay, so however, any innovation which transforms the abstract principles into a real world tangible application, it may become a patentable subject matter. So for now, the guidelines are still being sort of developed. Okay, so what you're looking at, we are at a very interesting phase in time where we are seeing the law being developed. Okay, and does not happen very often. So this is one particular area, computer related inventions. With every day, there is a new case law coming in, and we are clarifying things better. We are sort of putting things in the boxes where they belong. And the gray area, which we used to call it, is slowly it is becoming much more aligned. So with that, I think the time is also coming to an end, but I would still like to touch base upon the curious case of Davis. So Davis is basically this device for autonomous bootstrapping of unified sentinels. So it is an AI system. It was created by Dr. Stephen Thaler, and it was trained to mimic the aspects of human brain function. So what this artificial inventor project, and please do look it up, what it seeks to do is it is seeking intellectual property rights for AI generated outputs. So it is patent, copyrights, anything which is generated in the absence of a human inventor or author. And the whole idea of this is to promote a dialogue, open a dialogue, wherein we see what sort of a social, economic, and legal impact these sort of technologies would have going ahead. Okay, so a lot of pro bono legal professionals have joined this project, and they are helping Dr. Stephen Thaler to take ahead these inventions, file in various jurisdictions pro bono, and then understand how each of these patent offices is reacting to their applications when they say that, look, this is a AI generated invention, we don't have a human face to it. So this is an example. If you look at it, it is a food container, and the devices and methods for attracting enhanced attention. And then look here, the inventor which is named is a Davis, that is the AI. Okay, so this particular application was filed in around 2019-20, and it has been granted a patent in South Africa. So this case actually became a very hyped case. It was a landmark decision wherein for the first time a patent office granted a patent wherein the inventor was not a natural person. So in South Africa, as well as one more country, in Germany, they have issued a utility model for it. Okay, and this particular invention was a food container which used fractal geometry. So if you look at it, this is a fractal geometry to make the packaging more attractive to the customers. So this particular application was also published as a PCT. The appeals are pending in these jurisdictions: UK, Switzerland, Canada, Europe. And the applications have been denied with a further possibility in US, in Australia, in Saudi Arabia, and Taiwan. In India, Brazil, Singapore, the application is still pending. So you can look up this application in the Indian Patent Office database website as well. So in India, interestingly, there is also a pre-grant opposition which has been filed, which says that since there is no natural inventor, so we cannot give it a patent grant. So subsequent to this filing of 2020, in 2021, there was a report number 161, which was submitted in the Rajya Sabha on July 2021. And what it sought to do was understand the evolution of AI and then its impact on various aspects of IPR regime. So it also reported that a report by Accenture says that AI-related inventions or computer-related inventions would add about $957 billion US dollars to the Indian economy by 2035. So that is a big number, and 2035 is just 10 years down the line. So we need to act fast and develop our IPR frameworks, implement a stronger IP network so that the Patent Act of 1970, the Copyright Act of 1957. Anyways, I feel it is high time that most of these laws would have to be sort of rebuilt and to suit today's issues, okay, and to facilitate inventorship, authorship, ownership by these new technologies which are taking over. So the report essentially said that it would be looking at various mathematical business methods, algorithms, computer programs by AI, which are not yet patentable, but they would be looking at the implications of how things could be improved to make it patentable. Again, the committee then recommended the department that the approach in linking the mathematical method or algorithms to a tangible technical device. So we saw that the per se was something which was used only for computer programs, but now they are saying that you should also look at mathematical methods and algorithms with from the way US and European Patent Office have been dealing with these applications. Okay, so the conversion of mathematical methods, algorithms, to a process in this way would make it easier to protect them under Indian patent regime. Now, following this in 2022, what happened was action was taken by the government on the recommendations, and these the committee recommended that the department should further channelize efforts to encourage and empower the AI innovators by enacting suitable legislations and modifying the existing case laws on IPR in order to accommodate AI-based inventions. So we are heading in that direction. This is 2022. If you look at it, 2020 was when the first AI-related application was filed, wherein they named the inventor as a AI, not a natural person. Then moving ahead in 2021, it was tabled, this particular report 161 was tabled at Rajya Sabha. In April 2022, the Rajya Sabha, then the government on the recommendations, they further directed the department to ensure that suitable legislations are in place. And then in 2025, recently, when these guidelines were further published, now the inventorship in AI-related applications, the guidelines say that there would be two categories. One would be a AI-generated invention, wherein it is created entirely by the AI system, autonomously and with very limited human intervention. So such AI-generated inventions are not patented. AI cannot be termed as a person claiming to be true and first inventor of an invention under Section 6 of the Patent Act. Similarly, AI-assisted inventions is the second category, wherein the inventions made using AI as an underlying tool. Okay, this is something that would have to be looked from the Section 3K perspective, from the non-test perspective, and then on a case-to-case basis, they would further judge whether this is something which meets the patentability criteria and demonstrates the technical effect which we are thinking of. Okay, so I think the time is already up. So with that, we can head to some questions, Dr. Munda.
Yeah. Thank you, Sneha, for this comprehensive delivery. There are a few questions in the chat box, and I'll point them out to you one by one. So there's a question from Dr. Kavita. She is asked, they have developed a comprehensive questionnaire tool in an app-based that is easy to use, less time consuming. It is non-paper based, and it comprises of different questionnaires in one with the interpretation and output, which is displayed to the concerned clinician. So what is your opinion on whether they should patent it? Do you suggest it to be patented?
So like I said, it is again a very, there are multiple things which we have to look at. What is the technology which you are using? That is the underlying thing. But just going at it, if it is just automation which you have done, like maybe earlier there was one person, like a medical transcriptioner, who would call up the doctor and then speak to them and ask them a questionnaire and then understand things and then transcribe it for the patient and send it to him. The same thing if it is done automated and done through a computer app or a mobile application, then that is something which we would have to check if just by looking at it. And I don't want to dishearten you, but then it doesn't seem like something which would have enough technical effect from the patent law perspective. Okay, so you can still keep this as your proprietary algorithm. You can still keep this as the know-how. So there is definitely IP in it, but it is not something which may be patentable. But again, that is an opinion based on just the 2 lines which you have shared with me. So there has to be a very elaborate prior art search done. There has to be an understanding of how this technology stands with respect to what is out there. So the novelty, inventiveness also has to be established. At the same time, the technical effect, so that they don't say that this is just an algorithm and does not have enough technical contribution.
Okay. The next question is from Bipin Deshpande. He's asking, would UPI be patentable? And if yes, what would the patent be for?
Would UPI be patentable, and
what would the patent be around?
Okay, so UPI, again, like I said, it is just a financial interaction which is happening. So it would most probably fall under a business method and something which you would not get a patent on in India. But you could still apply for a patent in US, European jurisdiction, because there they are much more sort of accommodating when it comes to these sort of inventions. So in India, just by looking at the current situation, it would not seem like, unless we are able to prove the technical effect of it, it just seems like a transaction, a financial transaction, which is done through some underlying technology.
Sure. Another question, is any special algorithm for hiding or showing some information on computer screen? Is it a technical effect?
It could be. It could be, reason being, when you look at the security systems. So here I could say that there is a pronounced technical effect, because if you're hiding something, then at the back end of it, there would be something which would go through what is already written. Then there would be sort of a brain of the algorithm which looks at what is it, what are those words which should be confidential, which should be sort of hiding, and which should not be presented. So that sort of a system, it may be a technical effect which you will have to do. So like I said, these days in these computer related inventions, which I also file, most of the time section 3K is cited in the first examination report. But then when it goes to the hearing stage, or when you file a response to your application, these are the case laws that we rely upon to sort of fight and sort of state out or make it more clear that what is the technical effect which is being produced. So in this particular case, I feel that it could be something which would be allowed by the patent office. But you will have to define the inventive step as well as the technical effect.
Yeah, okay. Another question is around the program for moving cable supported cameras, like in IPL cricket. Would that be patentable? Which parts, basically, the cable
Sorry,
suspended
for
cameras,
a program for moving.
for moving cable supported cameras, would that be patentable?
Okay. Um, so what is the technical effect over here? That I'm still that is something which will have to be seen. But if it is able to sort of, if the camera is being moved so that it is able to better capture certain, maybe for surveillance, maybe it is something for security purposes. So if there is a technical problem which is being solved, so the camera is moving on the cables so that it is able to further, maybe for better traffic control, then that is something which would have sort of a technical aspect to it, and that is something which you could file a claim on. So just the moving part of the camera on the cables with the help of algorithm is something which will have to be looked at. There's no yes or no to it.
There's one more, which Pranav asks, if our patent claims a software hardware system, how far does protection extend to the software or hardware on their own? And does our disclosure of the system expose the components to be used separately? Do we need a separate product, computer program, and apparatus, which is hardware, to claim to protect each component separately?
Okay, so I think there were 3-4 questions in this. I will come one by one to it. So first part was whether a hardware plus software system is essential. So let me tell you, we have filed sort of applications which had a very strong IoT based system which had some hardware aspects to it, and then there was an underlying software to it, and it was producing a technical effect. So it was monitoring a certain landslide, and that is something which the patent office allowed. Similarly, there was another hardware plus software system, which was a test bed, and essentially it was just to study how the effect of landslide would be. And so the test bed had a hardware component to it. It was mimicking how the landslides function, and then the algorithm underlying it was measuring the signals, various parameters, thresholds. But the patent office said, look, there is no technical effect to it. So these two are examples wherein in one case they said, okay, it is solving a real life problem. It is solving a technical problem with a technical solution. And at the same time, in the second case, they said there is no technical problem which is being solved because this is only for educational study purposes. And you're just automating the system, just mimicking how it would work, and then the underlying software is just churning out some numbers, which is essentially just an algorithm doing its function. So, so hardware, while earlier it was a very essential part that if it is a hardware plus software system, then you could easily go and apply for a patent application. These days, we are seeing that the patent office is still quite critical about if the algorithm does not have enough technical contribution to it. Similarly, uh, coming to your second question, whether a novel hardware is something which is important. So like I said, there was a case law which states very clearly that your invention could be running on a general purpose computer, but as long as there is a technical effect. So when we look at compression algorithms, for example, the entire thing is running on your normal PC, but it is helping to improve the efficacy of it. It is helping to improve the way things function, making it faster, making the entire system. If there is some embedded hardware to it, if it is making it function in a better way, then that is something the algorithm will be patentable, even though the hardware of it is just a general purpose computer. So there is no requirement of a novel hardware per se. Okay, but again, it is the non test also you have to keep in mind that if you don't have a novel hardware and if there are multiple people who are developing similar sort of a system, so per se the algorithm is not something which you are able to patent, the computer program as such. What you are patenting is a system, method, or a process claim. Okay, so when it is a system, you will have to ensure that the hardware plus software system qualifies on the aspects of novelty, inventive step as well with respect to the prior art. And only then it could be patentable.
Sure. There's a question from my colleague Richa Arya. What could be the supporting data for an AI assisted invention? Also, how the diagrams play role in this context?
Diagrams play a huge role because when you look at a diagram, if it is not clear whether it is just a flow, if it is just a flow, the patent office may come back saying that this is just a algorithm and you have just given the process steps of it. But if it is, can you please repeat the first part of a question?
What could be the supporting data for AI assisted inventions?
So AI assisted, if you're working, the AI is actually working with some sort of a hardware component wherein it is taking the data from that particular, let's say, sensors or some sort of a hardware and then further processing it. Then in your patent application, it is always good to mention the hardware component as well. So when you project it or when you draft it as a system claim or a process claim, don't just give the flow of the process, but also give out the entire system flow. So your claim generally should have at least one system claim, at least one method or a process claim. And apart from that, if there is some novel component, hardware component to it, that also should be one claim. Also, one more important thing is that when you are structuring your claims, ensure that the technical effect is something which is obvious through the claims per se. So it should not be just the algorithm. So for example, algorithm for churning out random numbers is something they would not allow. But if it is an algorithm for churning out certain data sets, so that it makes sense and if there is a technical effect which is produced. For example, let's say the volume of your brain is being measured by putting in all these MRI scans. Okay, so here multiple things are happening. Or if your handwritten notes are further then they are so through optical recognition, if there is a sensory input to it, then there is some sort of a brain of the algorithm where it decodes the handwritten message, then makes it into a digital sort of a digital platform and then further processes that data to give you some meaningful output. Then that is something which, although it is just an algorithm, it could be patented.
Someone wants to know what is the success rate of getting patents in CRI in India?
So for now, I have been quite happy with the way patent office is dealing with these. Whatever I have talked through in these few slides, if these things are brought out, like the technical effect is brought out clearly, if the inventive step is brought out clearly, if the hardware plus software, if there is no hardware, how it is actually helping the computer function better, or how it is protecting your system, and whether the invention is something which is just a user interface sort of just crunching out abstract numbers, or if it is something which is actually having an effect on the way the system functions at a core level. If you're able to bring that out, I have had a good sort of a response from the patent office in getting grants on these sort of claims. But again, like I said, it is a evolving sort of a field. So there are many things, and small, like the way the claim is drafted also has a big impact on whether it would go for a grant or not. So these things have to be kept in mind while drafting it as well. The language plays a very important role.
There's one last question, probably not right for today's talk, but I'll just read it out. Can one do a prior art search using AI tools like ChatGPT? If yes, how reliable they are? Is there a confidentiality risk? Is there any AI tool for prior art search?
So you could do a prior art search, and even these days, like AI, I'm sure there would be many tools. I myself have not used any of these because I prefer to do it in the traditional way. But you would get out a good output out of it, because these days even the patent offices are incorporated a AI sort of component to the searches which they are carrying out. Okay, so for them also it has become an essential part in sort of getting the prior arts easily available, which are closest to your application. And I have seen that the patent office searches have improved tremendously. Like earlier, there was a chance that they would miss out on a close prior art. These days, it's not happening. So I am assuming there is some sort of a AI component which is inbuilt in their system as well these days, and so you can look at it. You can look at it, and then of course there are certain things like which you. So AI is also generating patent drafts these days. But then something which is specific to Indian patent law is what you would have to look at, because the European and the US patent law and most of these AI softwares would be something which are created with that patent law in mind. So they may not churn out essentially the right sort of prior arts in your case.
All right. So the questions from the chat are done. In case any of our team members want to ask, you can unmute and ask. But before we move on, let me alert everyone. The feedback link is in the chat box. Please do give your feedback. We see there are only just 1 or 2 entries, people who have given feedback. We do consider your feedback very, very critical, mainly for knowing what other topics you may want to listen on. Also, let me alert the participants. Our next talk in this series is going to be after Diwali, which is 2 Tuesdays from today, 28th of October at 4 p.m. So please stay tuned for the next talk, and that's going to happen 2 Tuesdays from today after Diwali. Any more questions from the team? You can unmute and ask. Otherwise, we can stop. It was wonderful having you, Sneha, today. Thank you for this elaborate session. And we look forward to host you for many more such sessions in person, offline, whatever is possible. So thank you so much.
Dr.
Yeah,
Mukta. It is always a pleasure, and I hope that today's talk actually helped clear out certain aspects. Actually, it is a very wide topic, so I have just
right.
been able to scratch the surface. But whatever I could cram into this 35
Yeah.
minutes, I have tried.
Probably an in-depth session is required to go into the nitty-gritties of this topic, right?
Definitely. So thank you so
Yeah,
much for having me today, and wonderful talking to all of you. Thanks a lot.
sure. Thank you so much. Bye-bye. See you.